Good day, and thank you for watching. If you're a beneficiary of a trust in California and you're thinking about challenging it, there is one clause you need to understand before you take any action. That clause is called a no contest clause, and depending on the situation, it can put your inheritance at risk. Let's start with the basics. A no contest clause is a provision in a trust that is designed to discourage legal challenges. It typically says that if a beneficiary contests the trust and loses, they may lose what they were supposed to receive. Now here's the key. Not every challenge triggers a no contest clause, and not every clause is enforced in the same way. California law has specific rules about when these clauses apply. Now let's talk about what that means. In general, a no contest clause may be enforced if a beneficiary brings a direct challenge to the validity of the trust without what is called probable cause. That's an important term. Probable cause means there is a reasonable basis, based on facts and evidence, to bring the challenge. If probable cause exists, the clause may not be enforced, but if it does not, the risk increases. Now here's where many people make a mistake. They assume that if something feels unfair, they can challenge it without consequences. But trust litigation is not based on feelings, it's based on legal standards and evidence. Now let's talk about the types of challenges that may be involved. Claims of undue influence, lack of capacity, fraud, improper execution. These are serious allegations, and they must be supported with evidence. Now let's discuss another important point, timing. If you are considering a challenge, there may be deadlines, and those deadlines can affect your ability to act. Waiting too long can limit your options. Now let's talk about strategy. Before filing a challenge, you need to evaluate the situation carefully. What evidence do you have? What are the risks? What does the trust say? Because once a challenge is filed, the process begins. Now let's discuss another issue, partial challenges. In some cases, a beneficiary may want to challenge only a portion of a trust, but even then, the no contest clause may come into play. So understanding the scope of the clause is critical. Now let's talk about documentation. If you are considering a challenge, gather information. Prior versions of the trust, medical records, communications, witness statements, because your case will depend on what can be proven. Now, let's address another common misunderstanding. Some people believe that if they lose a challenge, they automatically lose everything, but the outcome depends on the specific language of the clause and how the law applies. That's why careful analysis is important. Now let's talk about the role of the court. If a dispute arises, the court will evaluate the challenge, the evidence, and whether the no contest clause applies. This is not automatic. It is a legal determination. Now let's look at the bigger picture. No contest clauses are designed to prevent unnecessary litigation, but they do not eliminate the right to challenge a trust. They create a balance between discouraging baseless claims and allowing legitimate ones. Finally, let's talk about expectations. Trust litigation can be complex. It involves legal standards, evidence, and strategy, and the risks must be understood before taking action. In conclusion, a no contest clause in a California trust can have serious consequences. It can affect your ability to challenge the trust and your right to inherit. Understanding how it works, evaluating your evidence, and considering your options carefully are critical steps. If you're dealing with a trust dispute or considering a challenge, don't guess your next step. Call us at 888-888-6582. I'm Vince Davis, and we are all in this together.